The Appellate Division First Department is now in session. Good afternoon. Welcome to the Appellate Division First Department's virtual argument session. Please listen carefully as I call the calendar. People versus Olga Loganovska is, I'm sorry, I know I have not pronounced the name properly, forgive me. That case is submitted. Galindo versus Hodminson. For the appellant.
Sorry, Stephen
Donnelly, 5 minutes. And for the respondent?
Good afternoon, Your Honor. Jonas Weig.
5 minutes. Liliani D. versus Linsford D. is submitted. Castro versus 243 East West 38th Street, submitted. Sealer versus AMA Consulting, submitted. People versus Taishi Nelsongil, submitted. Weinrauch versus New York Life Insurance, submitted. Palmer versus Spadoni Palmer. For the appellant.
For the appellant, Adam J. Edelstein. For Melina Spadone.
7 and 2. And for the respondent?
For the respondent, Gassman Biamonte Gruner, PC, by Rosalia Biamonte. Good morning, Your Honor.
Good afternoon, and 7 minutes. Alam Ahmad, there are 2 appeals on this case. For the appellant?
Michael Ledley, I'm sorry, I had my microphone muted.
For Alan Ahmad, you said your name is?
Michael Ledley, along with Maren Deutsch.
Thank you. You have 3 and 1 on each case, and I'd like you to argue them together, okay, at the same time. All right. And for the respondent?
Yes, Your Honor. Tom Warren for the respondents. I am pro
You're
hoc.
here pro hoc vice. I will grant the motion. I understand the circumstances, and I've given you 3 on each case, again, to be argued together. So it's really 6 and 2 and 6. Understood?
Understood. Thank you, Your Honor.
Yes. Nicole W. versus Lewis T. submitted. Rossi versus 88th Street Garage Corporation. For the appellant?
Ira S. Slavitt.
That's 5 and 1, Mr. Slavitt.
Thank you.
And for the respondent, 88th Garage Corp.
Yes, Patrice Coleman from Pillinger Miller Torello.
4 minutes. And for the respondent, Zipcar.
Good afternoon, Your Honor. Stephen Zaklukevich for defendant Zipcar, Zaklukevich, Puzo, and Morrissey.
4 minutes.
Thank you.
People versus Scott Ewart. For the appellant.
For the appellant, Hunter Haney.
That's 4 and 1. For the respondent.
Felicia Yancey, Your Honor.
4 minutes. Bliss World versus 10 West 57th Street. For the appellant.
Norman Flitt, Rosenberg and Estes, request 6 and 2.
And for the respondent.
Stephen Stimmel, Brian Cave, Leighton Paisner.
6 minutes.
Thank you, Your Honor.
Bison Capital versus Hunton and Williams. For the appellant.
Good afternoon, Your Honor. Matthew Press of Press Corral LLP on behalf of Plaintiff Appellant Bison Capital Corporation.
6 and 1. And for the respondent.
Yes, good afternoon, Your Honor. Anthony Sylvester.
6 minutes.
Thank you.
You're welcome. De La Cruz Barras versus Allen Rena Realty. For the appellant.
James Healy of Sullivan Brill. Good afternoon, Your Honor.
Good afternoon. 5 minutes. And for the respondent.
Dan O'Neill, Bogerman, Cordy, Androvic, and Hurley.
5 minutes. Thank you.
Thank you.
Fortune versus NYCHHC. For the appellant.
Good afternoon, Jameson Davies for Health and Hospitals Corporation.
And that's 2 minutes. And the respondent has submitted. AM versus Holy Resurrection. For the appellant.
Good afternoon. Jeff Herman from Herman Law on behalf of Appellant.
That's 5 and 2. And for the respondent, Holy Resurrection.
Howard Cash from Stephen Goldstein's office.
3 minutes. And for the respondent, the Archdiocese, or Greek Orthodox Archdiocese.
David Rutherford and Christie.
That's 3 minutes as well. Lim versus MTA, 2 appeals. Both are submitted. And Abreu Dupina versus Weber, that's also submitted. Council, please remember, as always, that we have your briefs, we have your record, and we are fully familiar with the facts of your case. So please go directly to the points you wish to make. Also, as is customary, please don't speak when a justice is speaking. This is particularly important now during the virtual arguments in order to hear the question that's asked. Also, please be sure to keep your mic muted until your case is called. And of course, try to remember to unmute it when it's time to proceed with your argument. Thank you for your patience. Okay, the first case for argument is Galindo versus Hodgmanson.
Hi, good afternoon. My name is Stephen Donnelly. May it please the court. I represent appellant Clementina Rodriguez Apollino. It is submitted that the scar that occurred from this accident that's shown on page 245 on the record of appeal constitutes a significant disfigurement as a reasonable person, as a matter of law, would regard that scar as unattractive.
Counsel, I have a question for you. Your client's scar is in a prominent location, and I will take it that it's 2.5 inches, but it's rather faint. It looks like the lines from one furrowing one's brow too much. Is this the kind of significant disfigurement, the kind of case that we should find significant disfigurement as a matter of law? Or so when it's this kind of faint line, shouldn't it go to the jury?
So the picture, if you look at page 245.
I've looked at all the pictures, yes.
Okay, I think the page on page 245 really shows the significance of it right down the middle of her face.
It is down, well, not quite the middle. It's sort of right above the beginning of the eyebrow. Of the eyebrow, it goes right there. But again, my question is the same. Is that the kind of significant disfigurement that
I submit it does, and I submit that it's not that faint. I do submit that some of the photographs were a little bit taken back, but the one that does show it clearly does show it prominent. It's right there. The IME, that's what we're mainly relying upon. That it did alter her physical appearance for the worse. I'm submitting that it's not trivial. It is based upon the photograph, but also the IME report of Dr. Libling that defendants conducted and plaintiffs submitted as part says that it can't be repaired, that it's there, it's permanent, and cannot be repaired by any visionist surgery or any mitigation factors. The one defendant in this case offered no opposition to the papers. The other defendant, the one that responded, has just submitted that it's always a question of fact. And I submit that this particular scar is such the prominent and is so visible that it did alter her physical appearance for the worse.
Counsel, this is Justice Kennedy. I want to look at the scar. How do you address the fact that the scar, it wasn't discolored, it wasn't raised? Because I also viewed the photograph. The scar is not raised, it's not discolored.
I think it's prominent. If you look at it, it's there. It's there's a line down the middle of her forehead. It starts from the beginning of her hairline and goes all the way down to her eyebrow. It's there, and again, some of the photographs, I wish there were better clarity, but the one that really does show it, and I'd ask when you're making the decision, if you just look at page 245, because I submit that it is there. And, I was trying to think of an argument, and the best I got was when Justice Potter Stewart said, I know it, obscenity when I see it. and this is it on the photograph. When you see the photograph, it's there. So I think it is prominent. I don't think that, plaintiff should have to pay, for the plastic surgeon to say what's there. I submit that the photograph does show, as a matter of law, that it altered her appearance for the worse, and it is a significant disfigurement.
Thank you, counsel. Mr. Zweig, I believe.
Yes, good afternoon, Your Honors. May it please the court. My name is Jonas Zweig of the Zweig Law Firm, counsel for defendant respondent Nectar Rodriguez. Your Honor, plaintiff appellant fails to address the actual appropriate controlling standard for significant disfigurement analysis. This court has clearly articulated in both Marciano versus Mason and Prieston versus Massaro that the standard by which a significant disfigurement must be reviewed is whether a reasonable person would view the injury as unattractive, objectionable, or the subject of pity or scorn. And these are inherently subjective determinations.
Well, Counselor, it's certainly not attractive to have a scar coming from your hairline down to your brow, which is approximately what this scar looks like in page 245, that particular photo. So why shouldn't we be convinced that she's entitled to summary judgment after looking at that?
Your Honor, as this court articulated in Prieston, reasonable people could differ as to whether a scar is a significant disfigurement, and these subjective determinations as to what is unattractive, what is objectionable, and what is an object of pity or scorn requires a trier of fact.
You agree that it is a prominent scar, right? It's right in the middle of her head, right?
Your Honor, this court determined.
I'm just asking that question. Do you agree with that? And that it's about 2.5 inches long. It does extend from the hairline to the brow, to the eyebrow.
Correct.
Do you agree with that as well?
Yes, Your Honor, but
and it is visible to the naked eye.
It is, but none of these facts are determinative, and it's axiomatic that a scar can be permanent, it can be visible, and it can be located in an area of prominence without still being an object of pity or scorn or objectionable. This court has stated it's an inherently subjective assessment, and an issue of permanence should not be submitted for summary judgment without determination by a trier of fact. The court in Jordan versus Mediate stated that quantifiable criteria are of limited use in matters of personal aesthetics, which are influenced by age, gender, and the cultural dispositions of the plaintiff and of the fact finder. There's been no showing as to the degree by which cosmetics could be used to address this scar. And indeed, while plaintiff appellant relies on the determinations of the defense plastic surgeon, Dr. Liebling, an actual close examination of his report and conclusions shows that this is not a dramatic scar. Dr. Liebling concluded that the scar in question presents, quote, only mild hypopigmentation and mild discoloration. And that's at the record between 196 and 198. Based solely on that conclusion, where this is a mild discoloration of the skin, that is, again, a subjective viewpoint as to whether or not that would be an object of scorn, pity, or an unattractive or objectionable injury.
Thank you, counsel.
Thank you, Your Honor.
Thank you both. Palmer versus Spadone.
Yes, my name is Adam Edelstein, and may it please the court, I represent the appellant Melina Spadone. Your Honors, in this matter, the thrust of the matter dealt with the respondent's application for a downward modification or essentially an entire elimination of his agreed upon spousal maintenance support.
I'd just like to ask you, just to clarify, there is no question that the husband was disbarred from the practice of law and was barred from getting any financial series license, and suffered trauma and PTSD, childhood trauma, I believe. There's no question about those facts. Those facts are not challenged. Am I correct?
I would have to splice that, Justice Renwick, because there was no dispute.
Well, let me just start then. He was disbarred from the practice of law.
The gentleman never practiced law.
Well, he had a license. Did he have a license to practice law?
Yes, he did.
And did he, disbarment means you lose the license. Did that happen?
Yes, it did.
Okay.
No,
And then he was in the financial arena, and he was barred from taking any financial series licenses. Is
well,
that
that's
right?
correct. He transitioned, and I don't think there's any dispute in the record or from anyone for that matter.
That's what I'm asking you. There's no question about that. And that he was let go from his place of employment. Is that right?
Correct, but ultimately resumed doing exactly the same thing. That
no longer with that company. He was not hired as an employee of that company.
The evidence at the hearing showed that after the
he no longer had the job he had when he was am I correct? Married.
That's correct.
Okay.
But he was
and there was no question, I think, that he had the trauma that he had during those factors that the court relied on below, that he had childhood trauma. I don't think there's
no dispute about that incident.
Okay. All right. Go ahead.
But just as a matter of just clarification, at least from our perspective, the gentleman, the respondent, did ultimately hang, for lack of a better description, his own shingle, and that's the Theseus company, and essentially became self-employed doing that which he had done successfully for many, many years. But as a parenthetic aside, there was also evidence that he was working with the Matlin, is the former employer, in a consulting manner. So even though they basically forced him out for their internal reasons, he did not stop doing the substantive work that he was trained to do, and he was extraordinarily.
Counsel, this is Judge Curran. Didn't the court, though, credit that he was earning some income and factor that into the equation? But also fact that he was earning less income and the wife was earning substantial income such that it was appropriate to no longer keep ordering maintenance?
Well, that's a twofold question, and I thank you for answering it. It is our contention first on the determination at the end of the decision when the lower court is revamping and revisiting an amount of child support pursuant to the guidelines, the Child Support Standards Act. With all due respect to the trial court, there was an error in her computation of what his income was from all sources while he was self-employed. We think that, in fact, I think the trial judge relied on the blanket statement saying he's not getting salary from the company he owns, which during an operative period of time, which was approximately 1 year, there was in excess of $1 million of income from different sources, including distributions from his former employment at Matlin and the money he earned while at Theseus. But I want to address the second point a little bit more strenuously, with all due respect. My client, when a payee is the recipient of maintenance pursuant to a divorce agreement, this was consensual agreement. The obligation to pay maintenance was done on consent. It was not a trial decision. The idea in the world of maintenance awards is to give the recipient, the payee, a chance to ultimately rebound, perhaps find employment, make a good living, maybe even resume living a lifestyle, in this case that she had prior to the divorce agreement. Now, her situation, which the JHO repeatedly referred to, she's wildly successful, she's brilliant, she's intelligent, she has a six-figure salary, is completely irrelevant. And what I often tell clients who are payors of maintenance is, listen, if you're going to be obligated to pay a 10-year maintenance obligation, but in year 5, your former spouse hits the lottery, that does not constitute a legal ground to get a reduction and or an elimination of
So let me interrupt you, though. That is in a situation where the move-in hasn't shown any change in their own circumstances. You're correct. You would not look to what the other, but once the move-in has made a showing that they've had a substantial reduction such that they are going to experience hardship in continuing to pay that amount, doesn't it then come into play what the other spouse is earning?
The threshold legal standard, actually in both respects, as it relates to the maintenance and the child support, is what happened that caused the job loss, the income loss, and was it through no fault of the move?
Well, you're going into the volition aspect of it, but I don't think you have any case law to show that that kind of volitional, that that kind of behavior is considered volitional in this case, that it can be used against him?
Because we can't find any case law, and we looked, that says the act of literally opening your mouth with your children next to you and drinking to an excess that you're intoxicated, and then subsequently getting into a car, getting pulled over, arrested, and pleading guilty to 7 felonies, which by itself, the plea requires you to admit that the act was intentional. So vis-a-vis the threshold standard of was the act volitional or involuntary, he pled guilty in a criminal court, said, yes, I did this intentionally. He didn't contest that case and say, here's my physician, here are my mental health providers. It wasn't my fault that I picked up a bottle of liquor and opened my mouth and drank it. So what I think Justice Kern was referring to is, yes, ultimately, Ms. Spadone, the appellant's financial circumstances would be relevant, but we have to get through 2 legal threshold standards before we address that. Again, the lower court made a finding and gave undue weight to Dr. Aronson. It seems like she hung her hat on the Aronson testimony, which was essentially saying it's not his fault. It's not his fault. That contradicts directly with the plea bargain.
Did you put in an expert of your own?
No, we did not. Dr. Aronson, I'm sorry, Judge, did I cut you off, Justice?
No, that's okay. I'll finish later.
Okay, I apologize. Justice Aronson, Marvin Aronson is a psychologist. He was a parent coordinator in this case for these parties, I think subsequent to the divorce where there were custodial issues. And he transitioned into becoming the therapist for Mr. Palmer. So irrespective of whether or not we brought an expert in as a matter of law, and this is mostly contained in our reply brief, and I know that the justices have read the same, Dr. Aronson was not qualified to give that opinion, which is a medical opinion that there is not only post-traumatic stress disorder, but that there's direct connection between same originating many, many years ago with the childhood trauma, a direct connection to him getting intoxicated, getting in his car with his children, and ultimately getting arrested and convicted of felony. So we did address the Aronson piece, but I just want the court to know that this potentially opens up a floodgate of applications for downward modifications, and this happens often when people are W-2 employees and they get convicted of a DUI and their employer says, I can't employ you anymore, you're a risk and this is bad for us, and you're gone and your income's gone. That gentleman or gentlewoman who applies for the downward modification and goes in and says, I lost my job because I had to take a conviction or a plea on a driving while intoxicated, support magistrates in family court don't even give a hearing because the case law is clear and unambiguous since I was admitted to practice matrimonial law, that if it's your fault, you can't get a reduction. What's the reason?
Thank you, counsel. You have some rebuttal.
Yes, I understand. Thank you.
May it please the court. My name is Rosalia Biamonte of Gaspin Biamonte Gruner PC, and I represent the plaintiff respondent Mark Palmer. I would like to first address the issue of the diagnosis of my client's co-occurring mental health disorders. And I wanted to clarify for your honors the fact that Mr. Palmer was not diagnosed by Marvin Aronson, as was erroneously stated by counsel. Mr. Palmer received his diagnosis when he voluntarily admitted himself to Hazelden Betty Ford for intensive inpatient treatment. His discharge records were received in evidence on stipulation of the parties and are reproduced in the record as Plaintiff's Exhibit 37. And it was at that time that he was diagnosed with the 4 occurring disorders, namely severe anxiety disorder, panic disorder, PTSD, and alcohol use disorder stemming from systemic and traumatic childhood traumas of physical abuse and sexual abuse from the time of childhood through adolescence. There was no objection of that. In fact, it was received in evidence on stipulation, and there's no disagreement with regard to these diagnoses. Marvin Aronson is Mr. Palmer's treating psychologist, and it was stipulated that his testimony would be received as a forensic expert in the issue of psychology. What Marvin Aronson's testimony was pertinent to was really twofold, Your Honors. First, it was to explain how the diagnostic criteria of each of those 4 disorders presented themselves in Mark Palmer, and also to try to explain to the court how the scientific research with regard to the issue of the interrelatedness between a patient who's suffering from the types of disorders that Mr. Palmer suffered with and the changes that occur in somebody's brain chemistry and functioning. And that was what Dr. Aronson's testimony was received to explain that Mr. Palmer, at the time of the arrest, had been experiencing substantial traumatic triggers. He had been experiencing sustained and chronic panic attacks. He was utilizing alcohol to quell those symptoms, to self-medicate the panic attacks. And it was all of the sequelae of the underlying co-occurring disorders that caused Mr. Palmer to improperly assess risk, not only for himself, but for third parties. And unfortunately, that involved the 3 minor children who were in the car when he was arrested. Mr. Palmer did not have the ability at that time, as explained by Dr. Aronson, to stop himself from drinking, because it was the only thing that he could avail himself of to quell the traumatic experiences that kept re-triggering and the panic disorder. He was arrested. He was charged with numerous felony counts, including 9 under Leandra's law, 3 for each of the minor children. He pled guilty. That fact is not in dispute. We are not saying that Mr. Palmer was not the subject who drove the vehicle and was arrested on the afternoon of 2014 New Year's Eve day. But what my opposing counsel is attempting to argue is the fact that this court should apply a concept of strict liability, that because he was arrested, he's somehow not entitled to a modification, which I would argue is not at all with the evolution of the case law. 2 cases which opposing counsel even cites in his brief discuss. The courts have, I'm sorry, Your Honor.
I was muted, I'm sorry. I didn't understand his argument to be quite that. I thought his argument went to a volitional aspect on your client's part, that if anything is volitional that reduces the income, then that does not qualify for a reduction in maintenance or child care payments, et cetera.
That was his argument, and Your Honor is correct, which is why Dr. Aronson's testimony was so poignant with regard to the fact that what Mr. Palmer was experiencing at the time of the arrest, the fact that he was incapable of properly assessing risk, the fact that he had no impulse control, the fact that he had cognitive impairment, memory
well,
loss.
He did have control to be in another relationship with another person and to be spending quite lavishly with that person and enjoying a certain lifestyle that he seemed to be able to control that.
Your Honor, he did have an ill-fated relationship of 4 years with somebody who was not a good influence for him during the time of his post-treatment. He did engage in, by, I believe, Appellant's account in the brief was a total of $84,000, of which he categorized as discretionary expenses over the course of 3 years. That's about $27,000 a year, which the court utilized.
It seems to me that everything that goes on here is not your client's fault. It's inappropriate girlfriend, her behavior, it's traumatic stress syndrome that causes him to do it. Is he responsible for any of this at all?
Your Honor, I think Your Honor misinterpreted what I intended to say. I'm not trying to say that Mr. Palmer is saying that nothing is his fault. In fact, Mr. Palmer has paid quite dearly for the mistakes in his life, including losing his law license, losing his ability to maintain any series licenses, losing his employment, losing his ability to market himself in any way other than an independent consultant. And the court, getting back to your Honor's point about the discretionary expenses, the court utilized those calculations as part of the de novo calculation and imputed income to him of $305,000, which was $120,000 above what Mr. Palmer stated to be his income. So the fact that he engaged in discretionary spending was taken into consideration when the court imputed income to him, and we're not challenging that finding. We did not prosecute our cross appeal. So that situation has been taken care of, Your Honor, in the decision.
Thank you. Mr. Edelstein, we're back to you.
Try to keep it brief, Justice Henwick. The discretionary spending, by the way, what Ms. Biamonte said, and this is perhaps a little bit picayune, the $27,000 per year was just on the girlfriend or former girlfriend. The gentleman spent like crazy after the resignation from Matlin. We're talking trips to Iceland, Hawaii, 5-star staycation in Manhattan at the Mandarin Hotel. We're talking hundreds of thousands of dollars after the resignation. Now, Ms. Biamonte is saying, well, only look at that.
Going back to the lavish spending, that was based upon the disability benefits, which ended in August 2017. The court noted that, and also the court did not credit the husband with certain payments in excess because of the lavish spending, which the court frowned upon.
Well, I do understand that, but what I was saying about Ms. Biamonte's argument is Ms. Biamonte saying, well, that was all taken into consideration at the very end of the determination when the judge, the lower court, JHO, got past making a finding that this wasn't volitional, and then that there was an extreme hardship. And by the way, the JHO said it's the stress. She literally used the word, I'm afraid that if I continue the maintenance obligation, it will cause stress to exacerbate his psychological conditions. Well, that doesn't make any sense to me. That's not a legitimate finding. What should have happened, first of all, we contest the finding that it was not volitional, but if you're going to grant a maintenance termination or some other modification, she terminated it entirely. She didn't have to do that. There has to, at least in my opinion, be an empirical analysis of the financial circumstances of the gentleman, and especially in this case, while the action is pending, while this hearing is going on, he's spending and spending and spending when that money did not have to be, because if you lose your job and you're making $1 million in the finance industry and you're looking at perhaps driving a taxi because your life is ruined, who in their right mind is going to spend this money on not going to a Motel 6, with all due respect to Mr. Palmer, but luxury spending?
Thank you, counsel.
Thank you very much for your time.
Thank you both. Alam Ahmad.
Michael Ledley, Wilmeth, Marr, and Deutsch for the defendants' appellants.
Tom Warren, Your Honors, may it please the court, for the respondents.
Yes, thank you. Counsel, if you would begin.
Yes, this is two appeals arising out of a dispute involving the IFG Fund LP, which is a private equity fund organized as a limited partnership. I'm going to address the appeal related to the accounting issue first. This is an appeal of a denial of the motion to dismiss the first three claims in the second amended complaint until an accounting is performed. Those three claims are legal claims for damages. It's well settled in the Simmons v. Doyle case, among many other cases, that an action at law may not be maintained by one partner against another until there has been an accounting. The court denied the motion, we submit erroneously, because he concluded it's not in the interest of judicial economy to dismiss in favor of an accounting at this point in the case. Understandably, we're 2 years into the case. I'm certainly sympathetic to the concern of the court, but the problem is that rewards the plaintiffs here and sets a bad precedent. The reason why we're 2 years into the case is because the plaintiffs originally pled the case inaccurately as involving a discrete transaction, just one 2015 transaction. And under an exception to the Simmons line of cases, if there's a discrete transaction and the dispute doesn't involve any examination of the books and records of the partnership, then no accounting is required. So that's how the case was argued to the court initially in the first amended complaint when we moved to dismiss and made the same argument. The court denied the motion based on that. It was a discrete transaction. Then the second amended complaint is filed, and the more accurate, but still not exactly accurate, disputed allegations in the second.
Counsel, this is Judge Kern. Doesn't the court have broad discretion, though, under the relevant case law to decide to dispense with the accounting in the interest of judicial economy and let the claims proceed? Isn't that really up to the court to make that determination based on the record before it?
I do not believe so, Your Honor. I think the case law is clear that you cannot maintain the legal action until there's been an accounting. The case law doesn't say it depends on the circumstances. There is a exception.
You're saying it's a black letter law that you can never dispense with the judicial accounting under any circumstances? Is that your position?
No, there are very narrow exceptions. One of the exceptions is where there's no accounting required because it's a discrete transaction and you don't have to investigate the books and records of the company. Another exception may be where everything related to the partnership is before the court, and so you won't have piecemeal adjudication because there's different claims involving different quantums of money going back and forth. So that there are exceptions.
So isn't the only real issue before us now, though, is how to divvy up the proceeds of this transaction? That there were $12 million, and how which people should get which parts of the money from that transaction? Isn't that the issue that really needs to be determined at this point?
That's one of the issues that needs to be determined, Your Honor, but that's not the only issue. There is a second component of their claim, which is that there was an alleged interest of the fund in this company called GIL. And
Counsel, I'm just going to say you probably should move on to the arbitration issue, which is, I mean, that's what my colleague is getting to.
Okay. Thank you, Your Honor. I will certainly do that. On the arbitration appeal, so the claims relate in part to a 2015 transaction pursuant to which the fund sold shares in a company called GBHL to Kenyan counterparties. The transaction documents for the fund's sale contains a mandatory arbitration clause under the Kenyan Arbitration Acts. The main document is called the share sale agreement. It's a
so, Counsel, let's get cut to the chase a little bit. So, as my colleague was saying, it's really a question of these funds, and your argument is that it's really under the share sale agreement, and the plaintiffs are saying it's really more under the limited partnership agreement because the funds just can't be divided. They have to be divided pursuant to the partnership agreement. In talking about the arbitration, the court is the one who has to determine arbitrability, and there's no clear statement by the parties that said we want to avoid the court. We don't want the court to look at this. We want the arbitration panel to look at this. So the court is the one who has to determine arbitrability, and that's what the court did here.
I disagree, Your Honor, respectfully. It's not an issue for the court in the first instance. It's an issue for the arbitrators in the first instance, and here's why. Because the arbitration clause recites that it incorporates the Kenyan Arbitration Acts, and under Rule 17 of the Kenyan Arbitration Act, which we've put in the record at page 104, it includes a provision that says the arbitral panel may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement.
Mr. Ledley, this is Justice. I'm sorry.
You can go ahead. I was going to.
This is Justice Sherman, but the plaintiffs are not signatory to the sales agreement, and there's no direct estoppel here.
There is direct estoppel.
No, it has to go through the preliminary. It's indirect.
The proceeds, the money that was received was paid to them. They collected the money pursuant to the share sale agreement, which they knew of, which one of the plaintiffs signed. And so they've
When you say that
accepted the
they
benefits of that
collected, when you say that they collected it, who are you speaking to? Who are you speaking about? The partnership?
The IFG, no, the limited partners who are plaintiffs to the action collected proceeds from that sale. They accepted the benefits of the share sale agreement by taking the proceeds.
And then the proceeds have to be split according to the partnership agreement. They can't just, isn't that right? It has to go through a second phase, right?
Absolutely, absolutely, right.
That's the indirect aspect, isn't it?
But the first question you have to ask is, what was the purchase price for the shares that were sold? There's no dispute about the amount of money that was transferred. There's a dispute about.
So this is Judge Kern. Even assuming you're correct that you'd have to look at the share sale agreement and make a determination as to how the proceeds should be divvied, the only reason that the plaintiffs have any right whatsoever to get these funds is because of the partnership agreement and the partnership provision that they get a certain percentage. So even assuming you have to look at the share sales agreement to make some kind of determination, how can they be the direct benefit where their benefit directly flows from the partnership agreement?
Because the money they received was paid pursuant to the share sale agreement. Yes, they get it as limited partners of the fund, but they wouldn't get a dime but for the share sale agreement. That's the point. That they
don't they only get a dime because of the partnership agreement, that they're 100% of their right to any funds flows from the partnership agreement, not from the share sale agreement?
It requires both. Both agreements are necessary components to them receiving money. The limited partnership agreement doesn't pay them anything because there's no funds to be paid unless there is a share sale agreement. You can't have one without the other. It's a ladder with one leg that's going to fall over. So they have, yes, you need to look at the limited partnership agreement, but you can't determine what quantum of money to distribute pursuant to the terms of the limited partnership agreement until you answer the question is, what were the financial terms of the sale? And that's reflected in the share sale agreement, which they're disputing. They're saying it wasn't the $2 million in the share sale agreement. They're saying it was the $12 million that was transferred to the fund, which defendants contend was $10 million of that was for a different purpose and was not part of the proceeds. It's important because the counterparty here is in Kenya. The witnesses, their witnesses are in Kenya. The documents are in Kenya. All that's outside the subpoena power of the court. So we're going to litigate.
Counsel, here we have, though, an arbitration agreement where none of them are signatories except one in his, not in his personal capacity. So none of them are signatories and bound in that sense. So the only way you can bring in that arbitration agreement is through your estoppel theory. And the mere fact that they may have to look at the share sales agreement to determine the appropriate amount doesn't mean they're getting a benefit from it. That's where I'm having trouble with your argument.
I'll try to rephrase it. It's not, they're two separate issues as to arbitrability. The issue of whether the plaintiffs are bound is because the money that they put in their pocket was paid pursuant to the share sale agreement, and but for that, there would be no dispute. There would be no question about what they were entitled to under the limited partnership agreement. So, and they knowingly accepted those benefits, and they're keeping them. They don't want to give them back, and they're disputing what that share sale agreement says in a forum where the Kenyan evidence is unavailable because it's in Kenya, as opposed to adjudicating it in Kenya, where there's currently an arbitration ongoing. It's been commenced. So we have duplicate proceedings here. With the
Thank you, counsel. If you just wrap up your thought there, I'm going to move on to count.
Sure. It only makes sense to adjudicate the issue of how much was paid to purchase the shares where all the evidence is in that component. So thank you.
Thank you. Mr. Warren. Mr. Warren, you have you're muted still.
That was my best point, Your Honor. Just briefly on the accounting issue, obviously, if the accounting rule, it's a judicially created rule that has built-in judicial discretion into it. You know, these are discrete causes of action, and as we point out, you know, the partnership agreement here is terminates after 12 years. And so it wouldn't be, the partnership not alive anyway. So, the Supreme Court did not abuse its discretion in deciding to handle all of these matters. All of the causes of action have accrued. We got a few months until trial. It was a reasonable decision. With respect to the arbitration, so in terms of who's supposed to decide this, the arbitrator or the court, it's sort of a cart horse problem for the appellants here, because before you get to the question of whether quote unquote interpreting the arbitration provision in the share sale agreement, you have to decide whether or not that particular agreement applies in the first instance. And so what Judge Ostrager was doing here was saying that that was not the relevant agreement for purposes of liability in this case. And that question is a question that is decided by the court in the first instance. Having decided that the partnership agreement was the relevant agreement, it doesn't matter, frankly, what the interpretation of the arbitration clause in the other agreement would be, or what Kenyan law would say with respect to it. With respect to the discrete transactions that are at issue in this case, the relevant question here is simply, look, this fund was supposed to invest in a variety of different things, and it did. This GBHL was one of them. There were some other things as well. The point is, you've got passive investors here, and they're expecting to get their share of the proceeds. So what we're talking about here, basically, whether it's this transaction or that transaction or another, is once the money comes into the fund, who gets it? And so, that is simply a function of the partnership agreement. And, not only are the plaintiffs in this case not signatories to the agreement, there's no claim that the sellers, breached that contract. There's no claim that when the money was transferred from the buyers, that the buyers did anything wrong, and the buyers to the sellers, that there was anything untoward about that. The only question is...
So this is Judge Kern. What about the fact that you would potentially have to look to the terms of the share sale agreement to decide what is an appropriate allocation of these monies between the plaintiffs and the defendants?
Well, as a practical matter, I think if you take a look at the share sale agreement, all it says is that we're giving you X amount of money. And ironically, the share sale agreement only says that we're going to get X amount of money when in fact they got more money than that. So
how does one determine the proceeds of the sale versus the fees? Wouldn't that be from the share sale agreement?
No, the share sale agreement doesn't speak to that at all, Your Honor. That really was it just says we're going to buy these shares. So then the question becomes, all right, once you've they cashed out their position in that, what happens? What happens with the money? So it's seems like a relatively straightforward call here that to the extent there was going to be any benefit to the plaintiffs from these transactions, it would all be indirect, because whether it's the share sale agreement or the sale of some other interest in some other investment, it would always have to flow through the fund, and then the defendants in this case would have to make the proper distribution of those funds, and that's where the litigation is focused. I would only briefly add that two quick things. There is the waiver issue as well. And while it is true that in certain cases you can act in a defensive manner, let's say for a while without waiving your right to arbitration, that's not what we have here. We actually had counterclaims that were filed by the defendants in this case. And while they say in their brief that they only quote unquote discovered the share sale agreement, like a year into the deal, the fact of the matter is that the primary defendant here was a signatory to that agreement. So it sort of stretches credulity to say that they didn't know about it. And finally, I would say that Mr. Ledley indicated that an arbitration is actually proceeding in Kenya. You know, this is a matter of some consternation. We have the Supreme Court here deciding that this case should not be arbitrated. And we have the defendants in this case sort of attempting to brute force that arbitration anyway, instead of having the issue resolved by this court.
Did the court not parse through and determine that some issues should go before the arbitration?
Well, it is true that some cause of action went to arbitration in the United States. So some piece of this case got carved out. What's going on in Kenya is the very same claims here that Mr. Ledley is asking this court to say should be arbitrated are already being arbitrated, even though Judge Ostrager said that they couldn't be. So we actually asked.
Just wrap up your sentence there.
Okay, yeah. We asked the court to enjoin it, but for comedy purposes, it was like, I'm not going to enjoin a Kenyan arbitration, but the spirit of what the court has done is being violated.
Thank you. Mr. Getchis, we're back to you.
Thank you, Your Honor. The Supreme Court did not say that there should be no arbitration here. In fact, the Supreme Court declined to compel arbitration. Separately, the defendants here commenced the arbitration. What Mr. Warren leaves out is then he went to court to seek an injunction of that arbitration, and Justice Ostrager denied that injunction. It was appealed. The denial was affirmed on appeal. So there is no impropriety with the maintaining that arbitration in Kenya. We have duplicative proceedings here. We think the CPLR 7503 motion should be granted because that would stay the court proceeding pending the arbitration that's already pending. So that's point one. Point two, the purchase price, Mr. Warren, if he's prepared to stipulate that the purchase price received for the shares was what was set forth in the share sale agreement, then this case could be resolved pretty quickly. But that's not their position. Their position is that purchase price in the sale share agreement isn't the real number. It's some other number like 12 million. And so the question is, what did the fund and the Kenyan counterparties agree to for the sale of the shares? And if it's not in the share sale agreement, it can't be anyplace else. So that you have to look at the share sale agreement and its validity or invalidity or any of that. Finally, as to whether the plaintiffs can be bound, the case law isn't that you only if you sue on the contract is it a direct benefit. The case law is if the money flows to you from the transaction, then it's a direct benefit. And lastly, on the accounting point, I would just raise one point, which is that this is a long-standing rule with respect to accounting and the requirement that you don't just go to court without seeking an accounting. The court can take judicial notice that there are many hedge funds and private equity funds that are organized as partnerships in New York. It's a major part of the financial industry in New York. And to allow plaintiffs through strategic pleading to evade that rule that you need to seek an accounting and just run to court, it would destabilize a big chunk of the financial industry in New York. So I think that the stare decisis considerations with respect to the accounting rule will weigh heavily in favor here of not, even if it is discretionary, not using the discretion to reward plaintiffs for strategic pleading, getting the nose of the camel under the tent with inaccurate allegations and then broadening the claim after that to be much broader claims that would require an accounting and examination of the books and records. So I appreciate the panel's patience and I'll conclude my remarks.
Thank you. Thank you both.
Thank you, Your Honors.
Rossi versus 88th Garage Corp. and Zipcar.
For appellant Ira S. Slavitt from Levine and Slavitt, PLLC.
You may begin.
Thank you, Your Honors. Good afternoon. The plaintiff's appellant respectfully submit that the motion court erred in granting summary judgment and dismissing their complaint on the basis that the wheel stop that plaintiff Deborah Rossi tripped is open and obvious, because reasonable people can differ as to whether it was unreasonable for her to have overlooked it under the totality of the circumstances, and thus there is an issue of fact in this regard. Generally, whether a condition is open and obvious is a question for the jury. To prevail on their motion, the defendants had to establish as a matter of law that the hazard was so obvious that it could not have reasonably been overlooked, or that it would necessarily have been noticed by anyone employing the reasonable use of their senses so as to
Well, you
make.
provided pictures here, right? That the husband took right immediately after the event? And
yes.
And the car stop, the wheel stop is pretty prominent. It's a big chunk of rubber or whatever it is, and it has a very different color than the floor. Isn't that right?
From the view of the camera, where Mr. Rossi was when he took the pictures, that may be so in terms of the instrumentality, but
well, there are pictures that are angled that are taken from different angles.
But there is not what I think one of the salient facts here, that for reason I don't know, but not in the motion court's opinion, is that Mrs. Rossi was walking alongside the driver's side of this SUV. This instrumentality is behind it. She can't possibly have seen that. It had to have been obstructed by the SUV. There's no picture that shows the view that she had. To rely on a photograph that shows a view of this.
Well, you didn't have to introduce the photos, but I mean, well, maybe the other party introduced the photos because you used them, didn't you? I mean, the photos, they show what they show, and from certain angles, it does not appear that the car is over it. But in any case, your client testified, didn't she? And said that she didn't look at all.
She said that, but she never testified. A few things on the positioning of the camera. Again, the only angle that counts is the angle that Mrs. Rossi had. The purpose of this picture is to focus on the juxtaposition of the vehicle's rear to this instrumentality. The claim is not focused on the instrumentality of the wheel stop so much as it's focused on the circumstances that were created by the garage attendant, first of all, not bringing the car to them as he clearly was supposed to, causing her to encounter the risk that was created by the
proximate cause was the trip over the rubber, the stop, not whether he brought the car or not, right?
I know, I respectfully disagree. The proximate cause has to be evaluated under the totality of the circumstances. And again,
counsel, I like to go back to the wheel stop because I've also looked at the photographs. Clearly, you can see the wheel stop. But even in your reply brief, you admit that your client said that the wheel stop was visible when she rounded the rear corner of the car. She saw it.
I again respectfully disagree. That is not what
your brief. Reply brief. It's on page 2.
She didn't admit that it was visible. I admitted that it was visible to make the point that it was only visible when she rounded the rear corner of the SUV. It was not visible to her at any time before that. So she has a limited opportunity to see it. It's not in her path to the rear of the vehicle. It only becomes an issue when she reflexively takes the one step backwards so she doesn't hit herself in the head when she goes to close the door.
Well, if it's covered by the car, how can she take a step back and trip over it? You said before that it was covered by the car. The car was over it.
I'm sorry, I don't
didn't
know.
show the vantage point.
It was the vehicle wasn't on top of the wheel stop. It obstructed the view of Deborah Rossi as she walked alongside of it. The wheel stop's a few feet behind the rear of the vehicle. It's physically impossible for anyone walking alongside that SUV to see what's on the floor immediately behind that vehicle. And that's what I think is a very key. This is not like she tripped over something that's in the middle of the garage. That'd be a different story. This is a trap for the unwary. She wasn't told, be careful, there's something behind that vehicle. There's no wheel stop in the adjacent parking space that's empty that she could have seen. Oh, there's a wheel stop there. Maybe there's a wheel stop behind this one. It was a complete surprise, completely unexpected. Your Honors, and I just want to touch on the feigned argument or feigned testimony, because I know that's the kiss of death.
Yes, you should touch on it because you're out of time. So get right to it.
Just for it to be a feigned issue, there has to be directly contradictory testimony. And she very simply was never asked, was your view obstructed she was only asked if she looked. Those are two different issues. I'm sorry the time went by so fast. I did want to mention a case that was just entered 2 weeks ago that I think is relevant, but I'll yield.
You have rebuttal. You have some rebuttal time.
Okay, thank you, Your Honor.
For 88th Garage Corp, Ms. Coleman, I believe.
Yes, thank you, Your Honors. May it please the court. I think that there's no doubt here that the plaintiff just never looked. I mean, it's really almost as simple as that. The wheel stop, there's a long line of cases that talk about wheel stops generally being not inherently dangerous. There has to be some fact in the record that
those cases, if I may, I'll refer to the condition of the wheel stop, the placement of the wheel stop, the appearance of the particular wheel stop. There's a very comprehensive discussion of that in PJI about wheel stops.
Yes, Your Honor. That's my point. I mean, there has to be some fact that somehow transforms it from not inherently dangerous to dangerous.
Counsel is saying that she couldn't, when she was approaching the vehicle, her ability to see the wheel stop was obstructed.
Right.
Well, and she wasn't able to see it until she was in a position where it caused her to fall.
Okay, well, first of all, to the first point of the claim of a view being obstructed, that's not what she testified to. That's an argument of counsel that she puts forth in her affidavit, which directly contradicts her testimony. Her testimony was never, I looked and I couldn't see it. Her testimony was, I never looked. And more to the point was, that's while she's walking alongside the vehicle. The accident happened further along, some minutes later, after she rounds the corner successfully, puts her bag in the hatch, and then when she goes to close the hatch, she doesn't do what I think reasonable people would do, very simply turn around and look. She never did that.
Why is that reasonable?
Well, because I think you look to see what's in your path. You're going to take a step back. Was there another suitcase there? Is there a wheel stop there? Is there a car there? I mean, it's instinctive to turn and look. It's not, that wheel stop was not obstructed at that point. Even if you follow plaintiff's argument, it was not obstructed. It was open. It was obvious. It was well lit. It was a different color. It was black and orange against gray.
All of this would have been prevented if your employee had done the job properly and brought the car to the customer.
Well, Your Honor, I would respectfully disagree with that. I would agree with the point previously made that there's no proximate cause. There's no proximate cause between that. In Walk Press, the plaintiff attempted to make a very similar argument that the plaintiff had been directed to get from point A to the bus by taking a particular path, and along that path encountered a wheel stop. They tripped and fell over. That has nothing to do with the fact that this wheel stop was open and obvious. It was not inherently dangerous. The area was well lit. It was differential color. And more to the point, the plaintiff's affidavit, the feigned affidavit, I think is very relevant. I would respectfully, I know you've read the briefs, but I think the testimony is quite clear. When the plaintiff is asked, did she ever see, she says, I never looked. When she's asked about the lighting, she's not amplifying or clarifying. She's testifying, I never saw it, I never looked, I have no idea what the lighting is. And yet in her affidavit, in opposition to a summary judgment motion, she says the lighting was dim.
Thank you, counsel.
Okay, thank you, Your Honors.
Counsel for Zipcar.
May it please the court, my name is Stephen Zaklakevich for defendant Zipcar. I believe that counsel for appellant is correct when he states that the only angle that counts is Mrs. Rossi's. However, Mrs. Rossi provides no angle for us to consider, in that her repeated testimony that she never once, as she transpired traversed the mere 20 feet from her location to the location of the fall, she never looked at the floor, even though there was ample lighting, and even though that the wheel stop was a different color than the gray floor. She never once took the opportunity to look. So we don't know what Ms. Rossi's angle was. Secondly, the watch press case, which was mentioned, states that as just the mere fact that the attendant directed Ms. Rossi to the location does not overcome the fact that, and it doesn't transform the wheel stop into a dangerous defect. She was directed to the car, but the wheel stop remains open and obvious, easily discernible, and did not somehow rise to a defect just because she was directed to that location. I would request that the decision of the lower court be affirmed.
Thank you. Mr. Slavitt, is it?
Yes, Slavitt, thank you, Your Honor.
Yes. You have one.
I'm listening to the respondents' counsels, and I think what they're really talking about are issues of comparative negligence, which are issues for the jury, not open and obvious, which is whether it's unreasonable to have overlooked it. Even if it's visible, that doesn't mean necessarily that it's an open and obvious condition. Walk press, there's no indication as to any other factors that might have contributed to defect being dangerous. And I wanted to mention the case of Serrano versus River Bay Corporation. It was decided or entered November 24th, 2020, just 2 weeks ago, for the point that even assuming, just for argument's sake, that the condition is open and obvious, in order for the complaint to be dismissed and plaintiffs to be non-suited, defendants had to establish that they operated and maintained the garage and rental facility in a reasonably safe condition. And in Serrano, the motion was denied, or it was reversed, and summary judgment was denied because defendants didn't establish through either someone of their an employee with personal knowledge or an expert as to what standards were, what's reasonably safe for a garage. There's no evidence in this record at all what the reasonable standards are, and for defendants' counsel to argue as they did that bringing the car to the plaintiff exceeded the standards of reasonable care isn't a valid argument without first establishing with competent proof what the standard of reasonable care is in the first place. And thank you, Your Honor.
Thank you. Thank you all.
Thank you, Your Honor.
People versus Scott Ewart.
Good afternoon. Hunter Haney for the appellant.
You may proceed, Mr. Haney.
The SORA court in this case took the remarkable step of a 2-level upward departure despite an extremely unremarkable set of facts. This was error. The allegations here involved the possession of 6 to 8 images of child pornography and satisfied none of the board's position statement criteria for an upward departure. Besides the low number of images, of which the board indicates that 10,000 is more concerning than 100, and here we have 6 to 8, there was no evidence that the appellant was collecting or viewing the pornography over a long duration,
well,
that these materials...
Excuse me, Judge Mazzarella here. Didn't some of the considerations of the court go to your client's articulated interest in sexual activities with children, with young children, that he also had recently poked some child in a swimming pool, and that's what brought him to the attention of the authorities. The court's decision didn't rest so much on the number of photographs, which wasn't a large number, as you said, but more to his interest in having sexual relations with minor children.
So, Your Honor, he did make a statement to police that effect. But at the same time, he also denied unequivocally that he would ever carry out a relationship with a child, stating that he knew it was wrong, legally as well as morally. And then on top of that, none of the actions that he was accused of near children were inherently sexual or even equated to sexual contact, as the board implied. And it's really noteworthy that the cases that have held even just a one-level departure was only necessary involved much more flagrant actual sexual contact or sexual misconduct.
Counsel,
or, for example,
if I may, this is Justice Kennedy, and there were other circumstances as well, because your client admitted that if a girl was receptive to his advances, he would further pursue a relationship with her. Your client, 57 years old, I know that there is a dispute as to whether or not he looked for girls in Tahiti, but he did meet with 2 children. One is 8 years old, and he said that he was aroused by girls 8 through 12. So those are also factors. Can you address those factors? That also the lack of any adult sexual relationship as well.
So let me just unpack all of those, just because there were a few allegations there just to address. Regarding the lack of adult sexual relationships, there was no evidence submitted to the SORA court to that effect. There was only just one short mention that he had never been married in the pre-sentence report. Obviously, that does not equate to having no adult sexual relationships. It
was in the
not
case
our
summary,
burden to.
counsel. It was in the case summary. That's what the case summary indicated.
It indicated that he had not been married before, not that he lacked adult sexual relationships. So those, again, don't equate, and it's not the appellant's burden
but what's
to
more
demonstrate.
troubling what's more troubling is the active interest, as has already been stated, the active interest that he has in pursuing a relationship with a child, and that aspect, as opposed to, I know there are cases where people have raped and are in a level 2 or have, done something else, but it's this active pursuit to carry out this active interest to pursue this and carry it out that seems the most troubling.
Your Honor, we're not disputing that that the conduct in this case justifies registration. He is without question registrable. What he did without question was wrong. But the board has established multiple factors for the court's consideration, and a wide variety of case law has developed over time. And even accepting the characterization of his actions as true and accurate toward children, it first of all does not amount to the sexual contact which has often been required for even a 1-level departure, let alone a 2-level departure. On top of that, going through the other considerations, there was no evidence that he was collecting this pornography over a long duration, that the materials depicted sexual contact or violence against children that were found, and that that he had any paid subscriptions, that he categorized or edited the materials in a broad collection, or that he masturbated to any of these images. There was simply no evidence of that. There were no videos found either, much less videos of a graphic nature. And
no,
it's
you're
not
right. To his credit, he admitted all of this. He confessed all of his thoughts and anything else. Seems that he truly wants help, but the fact remains that the court took into consideration the things that he said he had an active interest, and there's a very vulnerable population of children who, unlike adults, which would be bad enough, can't necessarily or don't know how to ward off someone like that. I mean, that is really the problem here, the concern.
Well, I think accepting that characterization would subject almost any child pornography possessory offense to a level 3 adjudication, which is plainly not the standard that this court has to apply. And I think it's really important that the court balance, and I'm not, even accepting that it did here because its decision was very cursory. Accepting that the court balanced the mitigating factors, I don't think it did it properly here. He was released to a halfway house early, which reflects an exceptional effort at rehabilitation. He has been gainfully employed, maintains many productive hobbies, including astronomy and building telescopes, including an award-winning one. He has many other interests in family history and so on. He enjoys the
Counsel, has he
extensive
completed any sex offender treatment program? Has he completed a sex offender treatment program?
I believe yes, he has. I don't know if he's, I mean, in the process of it, it's required under the law that he continue in sex offender treatment as a result of his risk level, but necessarily before his federal release and his early release, he did have to engage in a treatment program. And I think that his statements, going back to Justice Renwick's point, really showed a mature understanding and an acute understanding of the consequences of his actions, and that was borne out in the letters of support to the SORA court. No one disputed here that his proper RAI score was 30, and it's really an exceptional case that actually warrants a departure all the way up to level 3. And a level 1 or 2 here is more than sufficient to protect the public and prevent recidivism.
Thank you. Counsel for the people.
May it please the court, Felicia Yancey for the people. Your Honor, as you correctly stated here, this is based on the totality of the circumstances. And what is important here, in more so than what was outlined in my brief, and also that's in the case summary, there's the presence of all of these different individual factors. But also what's important is that what's missing. And what is missing is there is no clinical assessment. There is nothing where, at least there was no documentation provided that indicate if he's been looked at by any professional and what that analysis would be. And as the board and the case summary stated, clearly if he had been analyzed and assessed as a pedophile, that would be an override and would automatically put him to a level 3, but we don't have that information. So with what is available at the time, level 3 definitely is warranted to give the highest protection at this point, especially considering the target, if you will, victims, that would be minors. Secondly, there's no documentation as to the defendant's enrollment in any kind of program, sex offender treatment program, or his progress and what the status, what the status of that would be and what his outcome is. If it's exceptional or not, we have nothing to support that. With also those, as defense counsel stated, he's conceding, I think, to a certain degree that it can go to a level 2. So what are we really asking? I mean, the main difference between a level 2 and a level 3 is that as a level 3 sex offender, the defendant would have to register his current address in person every 90 days. And that doesn't seem too much to ask, considering the totality of the circumstances here and the potential, especially without any documentation.
Excuse me, does it change where he can live?
No, the restrictions would still be the same as they would be with a level 2. It's just that he would have to register in person every 90 days with the authorities, so they could have at least that frequent contact, and then for 90 days every 3 months, basically they could stay abreast of where he's located.
And all of that, Ms. Yancey.
I'm sorry.
The level 3 sex offender cannot live within a certain distance of a school.
And I believe it's the same for level 2 as well. So seeing no further questions, the people rest on their papers and ask that the judgment be affirmed.
Thank you. Mr. Haney, you have a minute?
Yes, just briefly, a couple of quick points in rebuttal. In terms of my adversary's contention that my client's case or my client's appeal should somehow be prejudiced because he hasn't presented clinical evidence, that's complete burden shifting. It's the prosecutor's burden to carry if she wants to establish an override at the psychological evidence, present that to the SORA court. They declined to do so here. And so the prosecutor has to carry its clear and convincing burden despite that. As to the question of enrollment in a program, at the hearing, page 11 of the transcript, it's specifically represented by defense counsel that he is attending individual and group therapy twice a week as part of his 10 years supervised federal release. So there is evidence in the record that he did and was participating actively in treatment, and there's no indication that he has been non-compliant since then at all. And finally, just to address the concern about SARA and residency restrictions, I believe my adversary is correct that there really is no fundamental difference as far as residency requirements go. The real difference here is just the degree and the frequency of check-ins. And given the fact that, again, there's minimal evidence here suggesting that that the circumstances were aggravating enough to warrant a level 3, we'd ask the court to at least reduce the level to a level 2, again, given the minimal difference between the two risk levels. There's just no need to do so to protect the public and prevent recidivism. Thank you.
Thank you. Thank you both.
Thank you.
Bliss World versus 10 West 57th Street.
Good afternoon, Your Honor. Norman Flake for the appellant.
Good afternoon.
This
Counsel,
case.
I'll just start off by asking you a question. Given the plain terms of the lease of the policy that indicated that an umbrella policy was allowed for insurance purposes, how did the court err with regard to their finding that the insurance policy was adequate?
By allowing by implication aggregate limitations of any type or amount that the tenant would unilaterally, indeed arbitrarily select.
So with regard to an aggregate amount, the tenant presented an expert that said that policies with an aggregate cap didn't exist. And so, you know, what was presented was what was reasonable and what was within the industry.
I have to disagree because that expert and our expert also testified that there are different types of aggregates. There's a per location aggregate versus a general aggregate. They unilaterally supplied a general aggregate, and under the blanket policy that they were entitled to have, that general.
Counsel, where in the lease is that prohibited? Where in the lease does it say that they're not allowed to get aggregate caps?
The lease does not specifically prohibit aggregate caps, but.
So how could it violate the lease to get aggregate caps?
Because it impacts upon what is unequivocal, $5 million guaranteed per occurrence coverage for any one insurance period. Aggregate caps, the way they have it, would substantially diminish over 2 occurrences at any one of the other 21 properties. By that third occurrence, we don't have the $5 million per occurrence. Now that means each occurrence. Let's say unforeseen circumstances like we have now. We have a terrible year. We have 5 different occurrences during that one terrible year. We're exposed because the general liability.
Counsel, how long was this policy in existence? I just want to make clear. So you're saying the policy does explicitly say that you can have an umbrella policy. It doesn't have anything in the policy that excludes aggregate caps. They had an expert that said that general liability policies without an aggregate cap don't exist. And this policy has been in effect for was it 8 years or some time now, that if there was some objection, should have been brought up before now, shouldn't it?
Well, that's why we have a no waiver clause. We inherited this building in 2012. Recently, this court in the Booston case rejected a similar contention. The tenant there said, well, our insurance has been the same and you never objected. Below, the judge rejected
Well,
that
here it's not
contention.
only that. I'm referring to the terms of the policy as well. We wouldn't just say that for the simple purposes, but there's the policy here.
We didn't know what the specific terms of the policy were until rather recently. And then 2 months later, we served a default notice. One of the
Counsel,
points.
didn't you wait to serve the default notice until after you had exposure to paying the termination fee? Isn't that very convenient timing? That
no.
The first time you objected to the insurance was when you had some real exposure under the termination fee, and up till then you never objected to it?
We never objected to it because we never got the certificates of insurance, which the tenant had an affirmative obligation to supply.
Did you ever ask for it before then, before the issue of the termination fee came into play? Did you ever ask for those certificates?
The only time I know that we ever asked for it, and there was a prior owner before that, was in December of that year, when somebody on another floor said, "Where are your certificates?" They got the certificates to them. The guy said, "Great, thank you." And then he gives us the certificates and we give it to Mr. Sterling, our expert, who finds all these deficiencies. Before that, we had no idea what the coverage was, and they had the affirmative obligation to tell us. And once we knew, we sent this default notice in February, unequivocally advising them that their coverage was inadequate. Landlords do that all the time. They put the tenant on express notice that henceforth and in the future, we're going to strictly enforce the provisions of the lease. You have X number of days to cure, and you better toe the mark. They didn't even, and this court observed this, when you sustained the denial of the, when you reversed the Yellowstone injunction and vacated it, you said that this tenant never offered to do anything retrospective.
So you can't, it's not disputed, you cannot cure an insurance default under the lease. That's why, that was the reasoning on the earlier decision, but that still doesn't support or go to your position of why it was a default under the lease, having the aggregate.
Because we didn't get the guaranteed coverage of $5 million per occurrence. It could evaporate. We could be self-insured without protection after only 3 incidents. And why? Because they didn't have a per location aggregate, which they could have obtained, and that was testified to. They had general. They could have provided in the blanket policy for a guarantee of no matter what, $5 million per occurrence for the Bliss property. They didn't do that. They never offered to do that. They just sat back and said, what we gave you is sufficient. And we showed through expert testimony that our insurance could evaporate, and that's a terrible thing to happen.
Thank you very much. Thank you. We'll hear from you in rebuttal again.
Okay.
Mr. Steimel, is it?
Mr. Stimmel, thank you. May it please the court. A couple of points in response. It was not only tenant's expert that said insurance without aggregates is not available, was not available on lease inception, not available during the decade that this lease has been in effect without any objection. It was landlord's own expert who said the same thing. And landlord's expert also said not all leases contain policy provisions setting forth aggregates. And that's what tenant's expert said as well. So sometimes it's not listed specifically in the lease what the aggregate's going to be. That's what happens because it's understood it's a standard policy, right? The leases don't contain many provisions that are in standard insurance policies. And this is no different than that, right? The lease, if it's deemed unambiguous, contains no prohibition against aggregates. Aggregates that are found in every single insurance policy. And this policy, which has been in effect for over a decade without any objection. You know, the court quickly understood what was happening here. Bliss had been in possession for over a decade without any objection by the landlord. And then landlord wanted to knock the building down to build a high-rise condo and needs to get rid of Bliss. Could have done it the right way, sent a termination notice, contractual, which would have required payment of a termination fee. If they had done that, Bliss leaves. But they decided they'd rather not pay that money. So they went on a crusade of defaults, all of which were rejected. Included in that was they argued that Bliss wasn't looking for space actively enough after receiving the termination notice, even though the court found Bliss looked at space in landlord's own building. They claimed that Bliss didn't have a special permit. The only reason there was any delay, which is not a default, is that landlord would not answer the phone if they saw it was from an area code where Bliss was located. This is why there was a breach of the duty of good faith, Your Honor. When it came to the insurance, there's no dispute. The lease records $5 million of per occurrence coverage. Bliss has $11 million of per occurrence coverage. That's undisputed. They would like to add some clauses in there that you don't have a right to do to substantiate a default. The court shouldn't read requirements into this lease that don't exist in order to allow this landlord to kick out Bliss when they've been there for 10 years without an objection. And the court really focused on the fact that prior to the defaults, months before the defaults, landlord requested copies of the certificates of insurance, which had been provided to the prior landlord. After some back and forth about they wanted a couple of things changes, which are not relevant to this issue, landlord said, great job, thank you very much. Not, that's no good. And in addition to that, prior landlord gave an estoppel letter saying there were no defaults. This landlord allowed this lease to be renewed in 2017, where an insurance default would be grounds to reject renewal. So what really just happens, they changed their mind when they didn't want to pay. So they decided not to pay, but that doesn't give them grounds to default Bliss on insurance that's been in existence for 11 years. And if the court were allowed to the interpretation of the lease to not allow aggregates, it would conflict with other provisions of the lease, which provide that Bliss should only have coverage that other tenants have, that is similar tenants. And since no tenant can get insurance without an aggregate, it would violate that provision. It would render the insurance provision absolutely meaningless because insurance would never be obtained. This is not an impossibility argument. This is not the Kel Kim argument that they state, where a tenant had insurance, lost it, and then couldn't get it back. And in response, instead of getting $2 million insurance, they got $1 million. We're not violating an express provision of the lease. And the same with the Booston case. The Booston case, the lease required $2 million of coverage, and the policy obtained only was $1 million in coverage. It violated an express provision of the lease. That's not the current situation here. Current situation is the lease contains no prohibition against aggregates, and all insurance policies contain aggregates. Every single one. It was undisputed. And the fact that we have other locations covered is a red herring. That can't be a basis to claim that the insurance is illusory or that there's a default, because again, there we have the express right to have that. So,
thank you, counsel.
Let me say this.
Yes, Mr. Newman.
Mr. Flick, there's no standard basis for aggregates. You can get a general, you can get a per location, you can buy $100 million aggregate. So for Mr. Stimmel to say that there is a standard policy is not correct. Further, the burden, the onus is on a tenant negotiating a commercial lease to make sure that they have insurance requirements that they can comply with. Kel Kim is indeed applicable more so because here they knew that there may be a problem with aggregates. We showed in our brief, pages 26 to 27 of our main brief, other cases where aggregates and specified amounts were set forth. You can't allow a tenant unilaterally and in the tenant's sole ability to eviscerate, render the landlord's insurance protection illusory. And that's what this would allow. That's not how real estate contracts are construed. Courts can't do this. And they say bad cases make bad law, hard cases make bad law. This is a hard case. It would be bad law to sustain Supreme Court's erroneous determination. And one last point on the good faith and on the other gratuitous Article 69. I mean, I have this saying, when the law's against you, the fact's against you, try to argue bad faith. This landlord acted only in good faith until such time as they submitted an application for a permit saying they were the owner. And then the relationship went downhill from there. On the $25,000, that should be vacated because Supreme Court itself said there was no proof, no connection. And the Article 69 declaration, that was their claim. They never pursued it. The only declaration there should have been in our favor. The claim.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you both. Bison Capital versus Hunton and Williams.
Good afternoon, Your Honor. May it please the court, I'm Matthew Press, Press Corral LLP on behalf of Plaintiff Appellant Bison Capital Corporation. In March 2004, Bison saved ATP Gas and Oil Corporation from the clutches of Cerberus, a vulture lender, by developing a new financing strategy and obtaining a new multi-year funding source, Credit Suisse, which went on to provide $8.7 billion in junk bond financing to ATP. Under the terms of Bison's contract with ATP, so long as Bison achieved a triggering event, Bison was entitled to a 1% fee on all funds made available or for the benefit of ATP.
So Bison didn't pay, obviously, and that's why you sued them. And at some point, you ended up bringing a malpractice action against your attorneys when they failed to file a lien, I believe. Is that?
That's what. Thank you, Your Honor. That's just one of many things that went wrong in the underlying trial. The case was for over $100 million in fees, and
a substantial amount.
Substantial amount. That's correct. And the Hunton Williams obtained a judgment of only 1.65 million in the underlying case, and then they failed to even obtain that amount by enforcing the judgment. Now, this case was decided. This malpractice claim was decided on a motion to dismiss a well-pleaded complaint, and but in dismissing the complaint, the trial court really effectively applied a summary judgment standard, and this is something that this court observed in the Wild Gottschall and in the IMO cases cited in our brief. Of other cases which were malpractice cases in which there was a very large record from the underlying case, and the trial court was tempted to treat that motion like a summary judgment motion, and went and made all kinds of impermissible findings of fact, weighed the credibility of witnesses, and
let's talk about this case.
Absolutely.
What was it that the court weighed incorrectly here?
Absolutely, Your Honor. Well, for one thing, the trial court got completely wrong the question. Now, the attorney judgment rule was the shield that the trial court primarily relied upon, and that states that an attorney is not liable for malpractice if the attorney chooses between one or more reasonable courses of action. But the attorney judgment rule doesn't immunize a decision that has no valid strategic justification, and the trial court here made a number of significant errors in finding that things that didn't have a strategic justification arguably did. Okay, and the number one point that I want to start with is that the fee provision required payment for funds made available to or for the benefit of ATP, and even though it made a difference of tens of millions of dollars in this case, Hunton Williams failed to come forward with any proof of what that provision meant in the contract, and it's such that the federal district court found that there was a complete failure.
Didn't the court, this is Judge Quinn, didn't the court base its decision in the underlying trial against Bison based on the court's reading of the Well letter and the plain text of the agreement? And no matter what other evidence came in, that wouldn't change that. That was part of the record, and that was what the court relied upon in rendering the decision it made in the underlying trial.
Your Honor, I'm so glad you asked that question, because this is a real misconstruing of that letter. Now, the letter you're referring to is an October 15th letter, and what the issue that the trial judge in the federal court found was that letter only went to whether fees were owed after the end of 2005. Okay, so that's transactions 4 through 13. That letter has no relevance to the amounts that were owed under transactions 2 and 3. Now, what I showed in my papers is that there was although the district court and the Second Circuit found there was a complete failure in proof in the meaning of that provision of what funds were made available or not. It was a hotly contested issue in the trial concerning whether amounts that were refinanced. Okay, there were a number of refinancings where there was an amount outstanding, $185 million, and the more money would be. It was refinanced on superior terms, but only a certain amount of additional money actually went in cash to the to ATP. And our position was that the full face amount of a refinancing was the benefit that that Bison was entitled to be paid for. Now, ATP said it was only for the new money, and so this is the very important part. Hunt and Williams completely failed to prove that the first financing transaction, the only one that ATP paid, was a refinancing. Now, that was a $185 million transaction. They paid a $1.85 million fee. Okay, and that is conclusive proof. There's a case, the Walter case cited in my brief, that says that post-contractual conduct is the best indication of a party's understanding of the contract. And that the voluntary payment of the $1.85 million showed that ATP understood that both the new money and old money were the basis for the fee payment. There was a $56 million in new money in that transaction, and if ATP had thought that the amount was supposed to be on new money, the 1%, then they would have paid $560,000.
If you could wrap up your thought, counsel. Thank you.
Thank you, Your Honor. They failed to introduce this evidence at all. Okay, they also Hunt and Williams also failed to introduce any evidence of the value of refinancing hundreds of millions of dollars worth of debt on superior terms. And this is something that's front and center in the case. There's just no reasonable strategic justification for failing to introduce evidence of that.
Thank you. Have some rebuttal time. Thank you.
Yes, Your Honors.
Yes.
Yes, may it please the court. This is Anthony Sylvester for respondent. As you heard and as we read in the papers, this appeal is a broad-based, all-encompassing attack on the court's decision below, that it applied the wrong standard, drew improper inferences, relied on wrong cases, weighed credibility, and didn't even address some of their arguments. And we disagree for all.
Counsel, can I just ask you about a much smaller issue, but one that I have a particular question about, which was the issue about filing a lien on their assets. And they claim in the complaint that they specifically requested that the law firm file this lien and that the law firm failed to do so. Under our very liberal pleading standards, why wouldn't that be sufficient as to that particular claim?
All right, on that particular claim, thank you for the question. Number one, there was an issue at that point, and the attorney judgment rule would protect with regard to whether or not on appeal there was a risk of, if you proceeded with enforcement, of any diminution in your judgment. That's number one. Secondly, there is nothing in the record that reflects that there is any real property on which a lien could attach. And in fact, the contrary is the case. There is no real property that is in the record in either in Texas or anywhere else that would have been available for a lien. And
doesn't that go beyond mere notice pleading, the argument you're making now, though?
Well, Your Honor, I'm looking at what's in the record. And the record, of course, was substantially, added to by some 18 exhibits to the complaint as additional 4 exhibits to the affidavit. But getting back to the filing of the lien, there also was the fact that there was a bankruptcy filing by ATP just 2 days after a judgment was filed against it. And I think it's clear, and it's in the record, that there was some $2 billion in secured debt against Bison. And I think Judge Starpula properly found any idea that you would ever collect is pure speculation. And in this pleading, there was the affirmative allegation that they would have collected the judgment. So they took upon themselves to make that affirmative allegation, as you point out in their notice pleading, and that's pure speculation, as Judge Starpula found in her opinion. Just to get back to, and I just wanted to provide some context to Your Honors. I was the only attorney who attended every oral argument before this motion, Judge. Judge Strapula had this for several years. She gave them and each of their new set of lawyers every opportunity, and she wrote 3 opinions here. They're all in the record. With regard to the issue of the judge's finding that there was an overriding problem with the criticism that an expert should have been presented, and that is the 2004 pre-litigation letter. And that articulated the parties' agreement, and Judge Stein read the agreement, read the letter, and enforced the agreement as he saw fit. Judge Strapula did not make any findings with regard to credibility or with regard to what that letter meant. She simply relied upon Judge Stein's conclusions and declined to, frankly, to overturn those. With regard to the issue with the SEC reports, which was front and center in their brief, that was an issue of whether they should be introduced. If you look at the trial record at 557, 558, it's clear that Judge Stein got it. And he said to the Hunt and trial lawyers, I understand there's a issue with regard to financial consequence. And why are you wasting time on this? He then turned to the other side and said, are you even contesting this? And the other side said, no, we concede it. And he turned to the Hunt and lawyers and said, move on. And like any other good trial lawyer, we've all been in a number of trials, taking your cues from the bench, they moved on. I do want to raise this, talk about the point with regard to this value. And that was, in fact, presented to Judge Stein. It's in the record that evidence was presented to Judge Stein. I want to point to R362, 379, 385. And the judge simply didn't buy it. He did not buy the point that each new loan should yield the 1% commission. And in fact,
thank you, counsel.
If I just might say, he said to accept Bison's interpretation of aggregate value would lead to absurd results, and that's a 442. Thank you very much.
And we're back to you, Mr. Press.
Thank you, Your Honor. Just to pick up that last point about the absurd results, that was because there was a failure of proof, and the Hunt attorneys didn't put in the evidence needed to show that ATP had actually agreed to pay a fee based on refinanced funds, and that can be shown on page 436 of the record in the findings and fact and conclusions of law. You see there that Judge Stein was under the misimpression that the $185 million paid in the first transaction was all new money. Okay, and that's something that $116 million of that was a refinancing of the prior loan that had been held by Cerberus. Okay.
There's a question from Judge.
Yes. If I heard your opposing counsel correctly, he said that there was no property against which to file a lien. Well, how do you respond to that?
It's very easy to respond. First of all, Your Honor, that this is getting far beyond the notice pleading standard. But beyond that, the complaint, well-pled complaint, does allege, and the record does include evidence that there were substantial assets. This is a Texas oil company. They have proven reserves, hundreds of millions in proven reserves in Texas and offshore. And I don't have the sites in front of me right now, Your Honor, but in my brief, in a section in the reply brief that addresses this, we cite to all the pages where various oil wells and oil fields in Texas exist. That's real property. You could file a lien on those.
Thank you.
Now, returning to the issues of filing a lien, as set forth in my papers, we demonstrated the Hutton lawyers' belief that there was any risk to enforcement while there was a pending appeal was just dead wrong. Okay, the federal law is unanimous that the Hume case and all of its progeny are clear that if you're appealing and trying to get more, you don't give anything up by enforcing. But here in the Second Amendment complaint, all we're talking about is filing liens, and so it's crystal clear that there was no risk at all to to Bison or to Hunt and Williams in merely filing the liens. And that's, if I may just wrap up one thing, it's very important. The bankruptcy, now there's the Linneman case cited in my brief makes clear that collectability is not an issue in which the plaintiff in malpractice claim bears a burden of proof. So We didn't have to carry that, and it wouldn't be appropriate to dismiss the case at the pleading stage on ground that there's an issue of collectability. That's a defense for much later on, Your Honor.
Thank you very much. Thank you both.
Thank you, Your Honor.
De La Cruz Barris versus Allen Rena Realty.
May it please the court. My name is James Healy and I represent appellant Joanna De La Cruz Barris in this matter. Good afternoon, Your Honor.
Good afternoon.
In deciding the two motions at issue, the lower court made three significant errors and its decision should be reversed.
Well, counsel, first I'd like to just ask you how you rebut the presumption that's created by the process server, the plaintiff's process server's affidavit with defendant's attorney's affirmation with no personal knowledge. I don't believe that Harold, who was served, submitted any affidavit. So how do you rebut the presumption created by the plaintiff's process server?
Justice Renwick, I would be more than happy to allow you to take over my argument because I think you can probably...
I don't want to. I just want an answer. So.
Sure. It's our position that the process server's affidavit is prima facie evidence of proper service.
Okay.
And that...
I'm sorry, I should have asked that question to the other side, but you answered it. Right.
That's fine. And it does bring me to the first point is that notwithstanding some of the arguments made in respondent's brief, every single department has found that a process server's affirmation is prima facie evidence of proper service. And then to challenge that proper service, you have to submit evidence in the form of usually affidavits contesting that. Their motion contained no affidavit, not from the person who was allegedly served, nor from the CEO of the company. Now, our argument is that that means on its face that motion should have been denied. Notwithstanding, we made a cross appeal and that was denied as well. And the cross appeal was simply that the court, rather than order a traverse hearing, which is in fact what should have been done, if we had been wrong on everything, we had a process server deliver it, they rebutted that presumption, the proper response from the court should not have been to dismiss the complaint, but order a traverse hearing. However, as the Court of Appeals has said in really the seminal case fashion page, the purpose of 311, CPLR 311, is to make sure that the corporation has notice of the complaint. And in this case, they had answered the complaint. There had been a certain amount of discovery that had been done. So we cross-moved. We served the Secretary of State and basically said, Judge, you can save judicial resources by exercising your discretion under 306 and just extend time and deem this service complete nunc-pro-tunc. And therefore, it's over. We can now get on to the merits of the case. There would be no prejudice to the defendants. They already had notice of the complaint, and it was filed within the statute of limitations. But by dismissing, even without prejudice, dismissing the complaint because of improper service, it destroys the complaint because we were beyond the statute of limitations. That cross motion was made not because we didn't think we would win opposing the original motion. It was strictly to preserve the judicial resources and prevent, frankly, what has occurred right here, is that now we're taking...
Thank you. You have, let me see where I am. Yeah. Mr. O'Neill, is it?
Yes, Your Honor. Daniel O'Neill, Bogeman, Cordy, Androvic, and Hurley for the respondent defendant, Allen Rena Realty Corporation.
So, counsel, I addressed my question to the wrong party. It really was meant for you. So I think you just responded with an attorney's affirmation that didn't have any personal knowledge. And so the question is, how do you rebut the presumption created by the process service affidavit?
Two reasons, Your Honor. I believe that one is, as a matter of law, plaintiff failed to establish proper service of process through the affidavit of service of the process server. And I'm referring to
Counsel, what about the legion of cases, though, that say if you leave process with someone who represents to you that they are a managing agent and authorized to accept service, that is a prima facie presumption of good service?
Your Honor, all those cases, including the Fashion Page matter, concern employees of a corporation where a process server went into an office and tried to serve one person who may have sent them to somewhere else, but they were all employees. Here, there is absolutely no evidence that this Harold Feuerman was an employee or an agent.
Well, he said he was the managing agent. At least that's what the process server said in his affidavit, that he said he was the managing agent. Wasn't that then, reasonable for the process servers to make that, have that assumption, that opinion?
Respectfully, I disagree. And that is because anybody could say that they are a managing agent or an employee, whatever. There was no proof of this. If he went to somebody on the street and said, are you related to Alan?
Counsel, he said he went to the office. He said he went to their corporate office. The person said they were the managing agent. Didn't you then have to come back and give an affidavit from the person who accepted service, at least from somebody saying, no, that didn't happen, or he wasn't the managing agent?
Actually, no, not in this situation, because the process server, number one, went to an apartment. And again, I go back to the Fashion Page case and other related cases in which it was an employee of the corporation. Here, there was no evidence that this Harold Feuerman was an employee. We can assume that he accepted these legal papers that were handed to him by the process server, but just because someone says they have authority on behalf of a corporation does not give them authority. And that's where plaintiff failed to establish that proper service was done. We're not talking about service on an individual, but we are talking about service on a corporation, which is pursuant to a different statutory scheme, not only pursuant to the CPLR, but the Business Corporation.
But according to the according to the New York State Department of State website, the principal place of the executive office was that apartment. That's
correct.
where he went. So
yes, but
you make it sound like it's like some random apartment.
Oh, no, absolutely not.
So that was an appropriate place to make service.
It may have been an appropriate place, but it was not an appropriate person. There was no indication.
Right. I think we covered that already, that person said in that place that they were the managing agent, and you don't have anything to counter that, at least not in the record from the person who the process server alleged made the statement.
Your Honor, in my reply affirmation, I submitted an affidavit from an officer of the corporation. He was just reinforcing what was already set forth, essentially what is in the process server's affidavit of service. This process server claims that this Harold Feuerman said
Counsel,
he was
the best way to challenge that is to have an affidavit from Harold Feuerman. I don't believe there is any such affidavit, right?
There isn't. I don't have control over this person because he's neither an officer nor an employee of my company. It may be in a non-party deposition or in a traverse hearing that could have come out, but I don't have control over this person. He's not related to my corporation that is the client in this matter. And again, simply because someone says they have authority does not mean that they do. This is a very specific, this is not like a suitable age and discretion type of argument, which plaintiff uses in their brief. This is, again, not to belabor this, but it's on a corporation.
Thank you very much. Thank you both.
Thank you, Your Honor.
Sure. Fortune versus NYCHH.
May it please the court. This court's precedents unanimously hold that a medical malpractice action must be dismissed, where after a plaintiff fails to file a timely certificate of merit, she also fails to show a reasonable excuse and provide an affidavit of merit from a physician in seeking to leave to file out of time. Here,
Counsel, in your brief, you recognize that there's a split in the department, right?
Yes.
With regard to whether we can automatically dismiss pursuant to 3012A. And the first department relies on a second department case, Sant'Angelo, that the second department overruled in Kolb. And it seems like the fourth department also overruled its prior case law, relying on the analogous application that Tawari discusses between 3046 and 3012A. What's your position, I guess, as to where we should be?
Yeah, so there is a split of authority in these decisions. I think this court cases all post-date Tawari, so there was an opportunity to consider Tawari, and I think Tawari is distinguishable on the basis that it deals with a statute that's really designed to funnel claims into certain procedural categories, whereas if you look to the history...
It really talks, I think the case analysis talks about the statutory construction of the case. So, the fact that it's to streamline, these medical cases and separate the chaff from the weeds or whatever it is, we're really looking at the statutory construction. Isn't that where we should be looking?
I believe
that's what the analogy is to Tawari, right?
That's correct, and I think the difference here is that if you look to the history of the CPLR provisions, the provision here, the certificate of merit provision, as a couple of cases have held, it was to eliminate kind of frivolous claims, or at least provide some hurdle. And if there's no potential for, after years and years of some kind of dismissal or some kind of other effective sanction, then that legislative intent is going to be thwarted. Whereas there is
an opportunity for dismissal if after the person doesn't provide the certificate of merit or follow the steps in 3012, then the court can order them to comply, and if they fail, then the court can dismiss based on a violation of the order. Couldn't it be done that way?
I don't think there's any dispute that it could definitely be done that way, Your Honor. But I think this court's precedents give a different route to that, which
right.
is
Well, I'm asking for. I understand what this case precedent is, but I'm saying the second department has overruled its precedent. So did the fourth, and there in Tawari, it seems like the very same analogy should apply. There was, I think. It was 3406A that the court said didn't have a mandatory provision. In 3406B, they said, well, there's a mandatory provision there with regard to dismissal, but not 34A. 3406A. So here we have a similar sort of construction. In 3012A, where does it say that there's automatic dismissal? We all agree that it doesn't. Right?
It does not. That's correct. And I would just say that I think it was not inconsistent with Tawari to imply that there could be a dismissal if the procedural steps outlined by this court were not taken, and similar to vacating a default where you have a similar sort of analysis where that is not actually in the statute, that you have to show a meritorious defense and good cause for the delay. But the courts have consistently applied that as the rule for trying to vacate a default. It's a similar sort of provision.
Do any of the justices have further questions? Okay, thank you, counsel.
Thank you.
AM versus Holy Resurrection.
May it please the court, Jeff Herman on behalf of Appellant.
Howard Kess on behalf of Respondent, Holy Resurrection.
Okay,
David
Mr.
Rutherford.
Herman?
David Rutherford on behalf of the
I'm sorry.
Archdiocese.
Yes, thank you. Mr. Herman, if you would begin.
Thank you, Your Honor. An employer is not vicariously liable for the sexual abuse committed by its employee. The reasoning behind this legal principle is that the sexual abuse is always outside of the course and scope of the employment. In this case, the sexual abuse was committed by a third party who happens to be the son of the employee. Now, the Supreme Court extended the legal principle and said that any family member of the employee would be subject to this legal principle that there could be no vicarious liability of an employee committing sexual abuse. It's an illogical and incorrect extension of the legal principle that exists in New York. And it's illogical because, as I said before, the reasoning for this principle is that the sexual abuse is always outside the course and scope of employment. In this case, if any third party committed the abuse, the question is whether or not the employee was negligent in failing to protect the parishioner who was abused. And so the inquiry should be, I'm sorry.
You go ahead.
Okay.
You just
the
finished.
Inquiry should be whether or not the employee failed to protect its parishioners by either acts or omissions. And the focus, when you look at that issue, you get to whether or not.
We're talking about the priest here who brought his son to the coffee hour. Did he, and he seemed or should have been aware that the son had some proclivity to sexually assault young children. He was a minor himself. Did
Correct.
The priest reveal to either the church or the archdiocese that his son had these proclivities? Did they have any idea?
No, he did not reveal that. But that only would go to the issue if he had revealed it, there would be a direct liability, direct negligence against the church and against the archdiocese. The fact that he didn't reveal it.
Okay, go ahead.
Well, the fact that he didn't reveal it doesn't impact whether or not the church is vicariously liable for his negligence. It's just like if he knew of another parishioner who had dangerous proclivities. He has a duty to prevent foreseeable harm. Now, there's no allegation that the priest intended for his son to abuse anybody. It was simply that he had knowledge that his son was potentially dangerous.
But how did you establish that the priest was acting in furtherance of the church's business?
Because you focus.
How is it?
Yeah, because the appropriate focus is what was the priest doing at the time when he made the decision or failed to protect the parishioners. And that is the priest was in the church running a mass. And then after the mass.
I don't think so. Not when he was running the mass. They were at a coffee gathering that I think he didn't even have to be at. It was not part of something they directed him to attend.
Well, they didn't force him to attend, but following the mass, the priest then attends the coffee hour in the church, where in this case, he was providing pastoral services to the family, talking about issues that the family were having, which is a reasonable extension of his duties of running the mass at the church. And so since this is sort of part and parcel about running the mass, he's still acting in furtherance because it's reasonable to expect that a priest would then counsel parishioners. It's because that is reasonable, it's an extension of his duties, and it's within a course and scope of his employment. And the reason his failures are within a course and scope of his employment is because at the time he is counseling and meeting with other parishioners, he is failing to monitor his son. He fails to warn the parishioners that his son may be dangerous. And it's these failures where the negligence arises from. Again, if this was a third party, another parishioner where the priest had noticed that was unsafe, then the priest is running coffee hour and he doesn't monitor this third party parishioner who he knows may be unsafe. His negligence then is failure to protect the other parishioners is within the course and scope of his employment, and therefore the church and the archdiocese would be vicariously liable. There's no reason to change it because it happens to be his son. Now, the defendant does raise the issue. Well, the church didn't know about it. We understand the church didn't know about it. That's why they're not directly negligent. If they knew about it, they would also have a direct theory. We would have a direct theory of liability against them. The other issues that arise here is that the knowledge that the priest has, because he is their agent, his knowledge is imputed to the principal. That is the fact that it doesn't matter that the priest learns his son is unsafe outside of the church. What matters is at the time he makes the decision not to monitor his son during the coffee hour, he makes this decision not to warn the family members who are there that their kids could be in danger. He has the knowledge at that time that his kid is unsafe, and therefore it is imputed to the principal, and that follows general principles of law.
Thank you, counsel.
Thank you.
Mr. Cass, for the church resurrection.
Yes, Your Honor, if it please the court. First of all, the priest was the substitute priest. He was hired or sent by the archdiocese to the church to perform the liturgy. That was the only purpose he was sent to the Church of the Holy Resurrection. He had no other duties. He had no duties to go to the coffee hour, and he had no duties to engage with the parishioners. It would be a terrible thing if at the end of that the liturgy tells, all right, your liturgy is over, get out. They're not going to do that to the priest. Secondly, none of them, neither the archdiocese nor the Church of the Resurrection, knew of the proclivities of PK. And third, if in fact what Mr. Herman was said, that the priest knew of his son's proclivity, he certainly should have taken his son out of the building and not let him be around during the coffee hour or anything else. And I think that the court below was very astute in its reasoning, and I think the opinion of Justice Heitler and the decision should be affirmed. Thank you, Your Honor.
Thank you, Mr. Rutherford.
Yes, may it please the court. This is a really very simple issue for the court, and that is whether the priest was acting in the course and scope of his duties or his employment when he kept from the archdiocese and the church the fact that his son, whom he knew to be a predator and have a history of child abuse, he kept that information. And why did he keep that information? He kept it for solely personal purposes. This is exactly what the standard is for outside the scope of employment. Mr. Herman, in his argument, keeps saying, well, if this was an innocent if it was a third party who did this, it wasn't a third party who did this. It was his son. And he acted solely for the purpose of allowing his son to go to the mass and keeping that a secret from everybody. That is a pure personal motive, and it's completely outside the scope. It's not in furtherance of the church's business, and that's the gravamen of the case. He kept it from everybody for his own personal motives.
Thank you, sir. Mr. Herman?
Yes, so the defense counsel, or the counsel respondent, Mr. Cass, states that the priest should have removed his son from the church after services before the coffee hour. We agree. That's what's called negligence. The fact that he didn't is what led to and proximately caused the abuse in this case, and which is why we have the claim. And then the argument that the fact that he did not tell the church, the priest, that his son was potentially dangerous would only be relevant if he was part of the abuse himself, the priest, if he was intentionally concealing it to allow his son to abuse. We're not, no one's making those allegations. We're saying he was simply negligent, that he had and whether he told them or not is really not relevant. What's relevant is that the priest, the father, had noticed that his son was unsafe, and under Restatement of Torts 315, he had a duty to protect the parishioners from foreseeable harm. It was foreseeable in his mind that his son could abuse, and therefore he needed to monitor and or warn the families. It really is that simple. And there's no basis to extend this doctrine that says that sex abuse is outside the course and scope of employment to family members of the employee. There's no basis, and it would be an improper expansion of the existing law.
Thank you.
Thank you.
Thank you all. This was the last case and concludes our argument for today. The oral argument is ended. Thank you. Have a great day.
Have a good day.
Thank you.